truth live from where they decree it. Sylvia speaks, no filter, no buffer. Courtroom drama couldn't get any tougher.
When the gavel's first bang, to the witness stands tears. Sylvia's lens captures all your hopes and fears. Uploading justice one trial at a time. Tune in every moment, edges sublime.
Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Faces tell stories, the courtroom can't hide. Sylvia's insights cut through the divide. From jury talks to the lawyer's secret. In Sylvia's world, you know you'll need it. Behind the scenes where whispers are loud, her lens reveals the truth in the crowd. Courtroom secrets laid bare to see. Stay curious with Sylvia Spree. Every objection, every sharp retort, Sylvia's there to give you the report. Exclusive footage no one else can snag. From catchy headlines straight to the tag. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show. Welcome to the Sylvia Show, oh yeah. She's got the inside scoop, don't you care? With every verdict, the suspense does grow. So hit subscribe, let's start the show.
Faces tell.
Hey guys, it's Sylvia. My apologies. I fell asleep on you guys, and I have 4 more parts to show you guys. But let me go ahead and upload this now.
About it, it clearly refers to both sides agree, or at least the witnesses agree. I agree. We got this death with, and then Ms. Boles asked, and the court needs assistance, headphones are great. Do I get to leave? The answer is no. The detective said today, not free to leave. She was not free to leave at that time. And then that would trigger no more communication or interrogation. Yet, as you continue on State's Exhibit number 1, you will see that the next officer continues the interrogation and initiates the interrogation. That's unlawful, and it must be suppressed. Okay. You could look at every case, but State versus Lee, L-E-E, it's 323 Georgia 704 927 Southeast 2D 286, decided March 3rd, 2026. It's consistent, the courts are consistent. This is de novo reviewed by the court. No one's saying anything happened outside of the audio video. No one said the audio video did not work. So, in our argument, but I believe it's an unequivocal request to stop the interview. She's in custody. She has to leave. She's told no. And then law enforcement re-engages the interview. So everything after the, I'm done talking about it, area should not be put.
All right, 323 Georgia 704, right?
There's several cases, but that's one, yes. It's
Okay.
just basic black letter law.
I understand. State argument?
May it please the court, Your Honor, I do agree with Mr. Steele that there must be a clear and unequivocal invocation of right to remain silent. That's what the case law says. That's to be clear and unequivocal. If you look at the video, around 28 minutes and 40 seconds, Judge. It is kind of hard to find if Your Honor goes to look for it. It's video number 2 on State's Exhibit 1. This is the second video on there of 3. It's so large they had to break it down into sections. So it's video number 2, State's Exhibit 1 at the 28-minute, 29-minute mark, 28:40. Detective Hardy confronts the defendant, says, "I don't believe what you're telling me, something thereabouts." And she says, well, it's the truth. I've told you several times, I've been in this room several times, I'm done talking about it. And she becomes exasperated, she becomes emotional, I'm done talking about it. And he says, well, you've never talked to me about it at all, because it's the first time he's ever talked to her in the investigation. She immediately regains composure and says, you're right, and continues on with the interview. And then another detective comes in, and they continue on without duress, without coercion, without promise of leniency, hope of benefit or reward, without fear of retribution for invocation of rights. So this is not a clear and unequivocal invocation of the right to remain silent or of an attorney. I don't think coercion, threats of harm, or hope of benefits really an issue here. It's really just the invocation of the right to remain silent. And I urge the court to rule that was not an invocation of the right to remain silent as much as it was just an exasperation of a person who was momentarily overcome by her emotions. I'm done talking about it, just as an exasperation. At no time, if she had said, I'm done talking to you, then we'd be having a different argument here. Or I'm done with this interview, I'm done with this, or something like that along those lines, and maybe we'd have a close argument. I'm done talking about it, just as an exasperation. That's not an invocation. And I'd ask the court to find that she freely gave that interview without hope of benefit or leniency, promise of reward, hope of reward, without fear. She was not in custody, she came there freely. Regarding the statement she made to Detective Hardy, he said, Your Honor will have to decide what she said. And she said, do I need to leave? Because they're all getting up to leave. Wicks and Hardy are getting up to leave. She said, do I need to leave? And they said, no, just hang tight. And they just had to see whether or not they were going to commence further interviewing or not. So I'd ask the court to deny the motion. And the rule of the state has the preponderance of the evidence proving that the interview was freely and voluntarily made, and that the defendant waived her right to remain silent, as the court did in its earlier ruling. Thank you.
All right, thank you. I'll issue the order. Next motion. We have kind of a quick one. The state served upon the defense a picture in life of the decedent, Daniel Akers. Defense objects to the use of that picture in life at trial. That picture was, at the time we served it on the defense, it was the only picture in the possession of the state, and it does depict the defendant as a child. He was to be about 10 years old, 12 years old, something like that. And we would have submitted that picture to prove a very critical, important element of the case, which the defense is aware of, that the decedent was right-handed. It shows the decedent holding a pencil, a pen in his right hand while he's writing on a tablet or a notepad. I do believe that that's likely overly prejudicial because he's a child. It depicts him as a child, it depicts him as a youngster. So we have obtained from the family another photograph that we have served upon the defense. Picture in life of the decedent as an adult. I'll just move to admit it. I'll show opposing counsel. I don't think it needs to be admitted, but I think the court does need to see what we're talking about. So I'll just mark it for demonstrative purposes only. States Exhibit 3 for the purposes of today. And it's been served on the defense some time ago as supplemental discovery. So I guess what we're doing is we're consenting to, just for demonstrative purposes, States Exhibit 3, we're consenting to the defense motion about the decedent depicted as a young preteen, early teens may approach number. I just ask the court to consider States Exhibit 3. We would seek to admit this photograph as a picture of the decedent in life, but not only to depict him in life, but to depict, there's going to be an incredible amount of controversy in this case that surrounds whether or not the defendant was right-handed, left-handed, or ambidextrous. And that picture, state contends, States Exhibit 3 for the purposes of this hearing, that clearly indicates or shows the decedent, who we believe is on the ladder on the right side of that photo before Your Honor, holding a hammer in his right hand. So we would contend that that's material
An essential element of the case on behalf of, for the state, we contend it's relevant on behalf of the state, and I know in speaking with the defense counsel, trying to work out the issues involving the decedent as a child, I know they're still objecting, it's my understanding, still objecting to the addition of this picture, rather than just hash it out on the day of trial, we'd rather just have a moving on it beforehand. So I guess we're partially, or we're totally consenting to not using the child photo. I agree it's probably overly prejudicial. But now we've come into contact since that objection. And we've come into possession of another picture that we do believe is not overly prejudicial and relevant and material essential to a contested issue in the case. Thank you.
All right, any response?
Your Honor, the claim is that Ms. Boles tells law enforcement that the deceased is ambidextrous. So we are going to object to what's now State's Exhibit number 3 for purposes of this hearing. I don't think there's any probative value to show at one moment in time a person is ambidextrous holding something in their right hand. It's just another in-life photograph of the deceased. There can be testimony about it, people know what ambidextrous means, and we would oppose the introduction of the photo. Clearly, there will be testimony about it, but I don't believe that if I'm ambidextrous, you can have a photograph of me holding a hammer in my left hand or the right hand. So I don't think that the photograph is needed at all. That is our objection. It's just another photograph of the deceased in life, which really does not help the jury at all. Because what does that really prove? One moment in time, a person uses both hands, is using their right hand. So the probative value is very, very scant. Why is it prejudicial? Under 4, the court has to ask, well, who cares? So you have a picture. The problem with it is, it's going to trigger us to get pictures. Same thing. Those pictures then could be trumped by other pictures. So, to me, there's no basis to introduce that photograph. I will say this. The original photograph was prejudicial, more prejudicial. It's why are we putting in, it's terrible now. This Boles feels worse to him. This was the father of their children. But why are we putting in any photographs that show this issue, which can be discussed? It's cumulative at best. So I ask you to exclude.
If I can add just another.
I want to tell you guys what this argument is about. The argument is about the state had submit a picture of Mr. Aker, the deceased. They put a picture of him using his right hand, and the picture is of him as a teenager. Let me show you the picture, what it looks like. Hold on a second. This is the picture of him using his right hand as a teenager. Let me make this bigger. Or using his right hand as a teenager. This is what their argument is about. They saying, Mr. Steele saying it's more prejudicial because they're showing a child instead of a grown man with the using his right hand. So the state agrees with him that the picture is more prejudicial than it is probative. You know, it's more it looks more terrible than it is to help the case. It's more it looks more against her because it's shown that hey, she unalive a young child. So and people would be more sympathetic towards that picture. So the state decided, yes, they're not going to use it. They're going to use a picture of him holding a hammer as an adult with the right hand. So Mr. and Mrs. Steele came back and said, there's no reason to add a picture in it because it's not necessary because then it's going to cause them to go find a picture of him using his left hand. So Mr. Steele's rather that there be no pictures added in there to show the difference him using the right hand. So that's what that's about. Okay, let me add this back in here. Hold on.
Response, I actually kind of agree with what Mr. Steele's saying, because what he seems to be saying is it should be considered by the jury for the weight of it, not the disability, for the weight of it. They can put any weight on that picture or zero weight. That's up to the collective minds of the fair and impartial jury members. And we're not shifting a burden of the defendant to do anything. If they choose to produce evidence that shows this man holding a hammer in his left hand, or a pencil, or a pistol, or whatever in his left hand, that's up to them. They have the right to produce evidence and the right not to. But this is a crucial element of the case. I know the court's not familiar with the facts of the case or the allegations of the case, but
Oh, I want to also tell you that when they found him, they found the pistol, the gun, closer to his left hand. And that's what they're basically showing, that he was right-handed. So it's not possible for him to shoot himself because it was on his left-hand side. But the argument with her, she's saying that her husband was ambidextrous, meaning he could use both hands. He could use the right or the left hand. Okay? But the state is saying that it is necessary for them to put a picture in there. That's what he's arguing right now.
the weapon we anticipated would be shown beyond a reasonable doubt at trial. The weapon used to kill Mr. Akers was found right under his left hand, almost in contact with his left hand, as he came to a final resting place, his place of death. So it would appear to, or could certainly be argued, that the left hand was used for this defendant. If you believe this is a suicide that was done by his left hand, if you believe it's a homicide that was placed by his left hand by the defendant. But what hand he used as his dominant hand is going to be an incredibly important part of this case, hugely important. And there can be testimony about whether or not he was left-handed, right-handed, or ambidextrous, but a photograph has no bias at all. It just shows what it shows. And if there's 50 other photographs that show a hammer in his left hand, fine. But this is the only photograph I have to show the guy that was right-handed. And I think that should go to the weight of the evidence, not the admissibility. I think the court should rule that the jury can consider it for whatever value it has in it. Thank you.
All right, anything else on this issue? No?
Not on behalf of Ms. Boles.
All right, I tend to think it comes in under Rule 403, based on what I've heard. The state will have to lay a proper foundation.
Will you draft orders? I guess the order would consent to their motion for the child photograph, but we can draft an order.
Well, I intend to issue an order on the motions we covered today.
Yes, sir.
All right?
There are some motions, surprisingly, that we agree on, so we can take those. Their defense filed a motion. There was a guy in Ohio who took a look at the 911 tape in this case. He gave certain opinions as a retired police officer. He gave certain opinions on what the 911 statements meant. The victim's voice on the 911 tape, things she may have said in response to the 911 operator, things like that. Defense has moved to exclude that. We're not calling that witness, just for the record. His name is Tracy. I think it ends with a CY. Harpster, Harpster. We're not calling that witness to testify about anything in this case, so we would consent to that defense motion.
Okay, thank you.
Everything else, I believe, would be contested. Maybe we could knock out. Oh yeah, there was a DNA motion. That's right. So the defense also, I guess, filed a motion for. I think it was titled or style, something like motion to receive or take possession of all DNA evidence in the case, something like that. Anyway, it's a defense motion that compelled. Here it is, motion for DNA testing and results. That motion. Judge, we've turned over all the evidence in this case as we have it as of June 2nd, 2026. We've turned over all the evidence we have in our possession. I've turned over all the crime lab evidence to the defendant, all the reports, all the records, all the testing, all the scientific reports. We don't know of any outstanding DNA. There were buffalo swabs taken from the defendant and from the decedent, but I don't know of any outstanding DNA That's the state's response to that motion.
Mr. Steele, want to say anything on that motion?
Your Honor, can I just ask you, granted, we don't have it in discovery, I just want to make sure that there's nothing there that the state, overlooked. I'm not saying intentionally, but overlooked. Also, Your Honor, on the issue dealing with the Lieutenant Harpster, Harpster, that was entitled Motion in Limine Number 2, filed April 29th, 2026. That was conceded, consented to, whatever the right word is, and I heard Your Honor, the court say something like, okay, so I assume that was correct. Without opposition.
Correct, yeah? Yes, Your Honor, that's all on that. Now, if you can look at motion in limine number 4, that's kind of a quick one. Defendant's motion in limine number 4, I don't think that'll take long to argue. What that says is, it says basically defense is moving to exclude any and all reference to bad character, prior gun violence, shoplifting warrant, and or drug use by Mr. Boles and or James Pogue, P-O-A-G. If Your Honor may remember, it's been a long time, the first interview was played with this defendant. There was a shoplifting warrant, I think it's a misdemeanor shoplifting warrant out for this defendant when she gave her first interview. And upon the conclusion of that first interview, she was actually taken into custody on that warrant, an open warrant, and arrested, processed. I think that case has long since been disposed of. We are going to redact the portion on her first video interview with law enforcement where they talk about, I think at the end, she says something like, okay, are we done? Am I free to leave? And they say, well, no, you've got a warrant out. We're going to have to take them into custody. We would redact that. We're not telling the jury that she has.
Oh my God, I'm trying to explain everything to you guys and it's been muted. Thank you, VK. I'm sorry. Okay, let me explain. I was stopping, pausing this to explain to you guys what this is. They were arguing about motion limine number 4. This is when during their interrogation, they searched and they found out there was a warrant out for her arrest that was from a shoplifting case that she had because they did some sort of diversion where she didn't go have to do time, but she was supposed to complete some stuff for the diversion of her guilty plea, but she didn't complete it. She missed her court date, so they put out a bench warrant on her. So when they put out the bench warrant, she never completed that whole thing. But then I guess they found out that she did complete it, but they still had that warrant out in the system, which nobody ever cleared it, right? So Mrs. Steele is asking for them to suppress that part of the interview. So the prosecutor is agreeing with Mr. Steele and saying that they're going to redact that part of the interrogation of the interview because it's more prejudicial than it is probative, meaning that it would look really bad against them once they mention that there was a warrant. It's gonna have the jurors to think more negative against her, and it's something that has nothing to do with this case. It's more of a bad act, and the prosecutor agreed that they were going to suppress that or to redact that part. That's what I was trying to do, explain to you guys that part. So that's what they're arguing about, and the prosecution is agreeing with Mr. Steele to redact that part. Okay. Thank you, VK, because I'm talking to y'all and I didn't see myself muted. Okay.
A warrant out at that time, do our best to redact that completely. So that takes care of the shoplifting part. Drug use by Ms. Bowles, we do anticipate.
Okay, now they're gonna talk about her drug use. Her drug use, because according to them, she's been using methamphetamine. So they want to keep that part in of the interrogation in there. I'm gonna go ahead and play it for y'all. I hope you guys can hear it because it's pretty low. One of the reason I do have a mic on my camera, but the where I was sitting at it didn't pick up. So now that I know the judge is pretty cool, I can sit more closer to the defense and have the mic on them. But or I'm gonna end up using a portable external mic, and where I could put it underneath the speaker and it can hear it better. Okay. It's this is like a dry run. It's my first time in that courtroom. I did not know what the setup. I did not know what the rules of the judge, but this judge is really, really cool. He doesn't. He just asked me to don't get in people's face and like disturb the court proceeding. But I have an opened Rule 22, so I know his rules and stuff. So now I know where to go and how to do it in his courtroom. So when trials start, I'll be a little bit better, hopefully. And I will do live stream from my phone because I see he allowed that too.
One. It's the second video on there of 3. It's so large they had to break it down into sections. So it's video number 2, States Exhibit 1 at the 28-minute, 29-minute mark, 28:40. Detective Hardy confronts the defendant and says, "I don't believe what you're telling me, something thereabouts." And she says, "Well, it's the truth. I've told you several times, I've been in this room several times, I'm done talking about it." And she becomes exasperated, she becomes emotional, "I'm done talking about it." And he says, "Well, you've never talked to me about it at all," because it's the first time he's ever talked to her in the investigation. She immediately regains composure and says, you're right, and continues on with the interview. And then another detective comes in and they continue on without duress, without coercion, without promising leniency, hope of benefit or reward, without
My apologies. Seemed like this
fear of
thing went
retribution
back
or
to the beginning. Sorry.
invocation of rights. So this is a young preteen, early teens, may I approach you on it? Yes. I just ask the court to consider State's Exhibit 3. You would seek to admit this photograph as a picture of the decedent in life, but not only to depict him in life, but to depict there's going to be an incredible amount of controversy in this case that surrounds whether or not the defendant was right-handed, left-handed, or ambidextrous. And that picture.
Sorry, I'm just gonna move it up a little bit.
Same thing. Those pictures then could be trumped by other pictures. So, to me, there's no basis to introduce that photograph. I will say this, the original has a difference.
Thank you.
Anything else on this issue?
Sorry, my thing. I did not know this thing was back.
I tend to think it comes in under Rule 403 based on what I've heard.
Yeah, we already heard this part. Sorry,
I
guys.
don't know of any outstanding DNA evidence. We turned everything over. If some kind of evidence like that materializes, we'd certainly give it to the defense. I don't anticipate that. There's no testing that's ongoing or being undertaken of any kind. So that's the state's response to that motion.
Mr. Steele, want to say anything on that motion?
Your Honor,
Who's the
I think
DNA
it's
person?
granted, we don't have it in discovery, I just wanna make sure that there's nothing there that the state, overlooked, I'm not saying intentionally, but overlooked. Also, Your Honor, on the issue dealing with the Lieutenant Harpster, Harpster, that was entitled Motion in Limine Number 2, filed April 29, 2026, that was conceded, consented to, whatever the right word is, and I heard Your Honor the court say something like, okay, so I assume
That's the one we
Defendant's
just
motion
talked
in
about.
limine number 4. I don't think that'll take long to argue. What that says is, it says basically defense is moving to exclude any and all reference to bad character, prior gun violence, a shoplifting warrant, and or drug use by Mr. Boles and or James Pogue, P-O-A-G. If Your Honor may remember, it's been a long time, the first interview was played with this defendant. There was a shoplifting warrant, I think it's a misdemeanor shoplifting warrant out for this defendant when she gave her first interview. And upon the conclusion of that first interview, she's actually taken into custody on that warrant, an open warrant, and arrested, processed. I think that case has long since been disposed of. We are going to redact the portion on her first video interview with law enforcement where they talk about, I think at the end, she says something like, okay, are we done? Am I free to leave? And they say, well, no, you've got a warrant out. We're gonna have to take them into custody. We would redact that. We're not telling the jury that she had a warrant out at that time. Do our best to redact that completely. So that takes care of the shoplifting part. Drug use by Ms. Boles. We do anticipate that the unfettered admission of evidence would show that she was using drugs, illegal drugs around this time, but it's not admissible. We're not gonna go down that road unless that door is open. And the way it could be opened is we've received an expert report from Dr. Matthew Norman, forensic psychiatrist in Atlanta, and he's moving, I guess he's being used at trial to suggest that this defendant's use or chronic use of benzodiazepines affected her ability to recall and affected her memory. So if there is extensive testimony from Dr. Norman about this defendant's use of benzodiazepines as prescribed, and how that may have affected her memory and recall, then I believe it is relevant for the state to inquire about how the mixture of prescribed benzodiazepines could have affected her memory and recall when they were mixed with illegal drugs, like methamphetamine. So I think we'll just have to wait and see if the door is open on that. We certainly don't intend to portray her as a drug user or an addict or narcotics user, but that door is I have reason to believe that could be open based on Dr. Norman's testimony, depending on what that turns out to be. Regarding, it says bad character, obviously we know the rules of character evidence. We're not intending to breach those rules. And then finally, there's mention by the defendant. And as far as, I'm sorry, before we leave the drug use, they're also lumping in this witness named James Pogue. We do anticipate calling Mr. Pogue as a witness. He will not be, we will not elicit testimony of drug use by him or the defendant or the defendant. So we don't anticipate that being a problem. We're gonna stay away from this defendant's use of drugs in this case until at such time as the door may be open. But we don't anticipate asking Mr. Pogue any of that. And the only thing that really remains as a sticking point on this motion is gun violence. I've talked to the defense about this before. There was an incident where there was apparently a get-together or a party at this house where Ms. Boles was located at some point, and there were some people on the back porch, the deck, and we expect the evidence to show through multiple witnesses that there was some kind of a disturbance. Somebody made a noise or shook the deck, shook the support beams of the deck and caused it to vibrate or shake, and everybody there, or many people there, got scared, including Ms. Boles. And her response was to go inside the home where this was, I believe it was her home at the time, to go inside the home and come out armed with a handgun to confront whoever may have shaken the support beams or rattled the deck boards or whatever. They thought it was, in talking with these witnesses, it's my understanding, they thought it might be some intruder or some stranger. Ms. Boles retreated inside the residence, came out armed with a handgun. Well, I think that's relevant to show she has the familiarity to handle firearms. This is a firearms death. It's uncontroverted that this is a firearms death. It's just who caused the death. The only issue for the jury. It's not a what is it, it's a who done it. So we think the use of firearms, the familiarity with firearms is relevant for the jury. I don't know that this qualifies as gun violence. It's kind of a general term used by the defense. I guess they're moving to eliminate quote unquote gun violence before the jury. That is the only, if I wrapped my brain around what I know about this case, that's the only thing I can even imagine that would come into the realm of gun violence. The gun was not fired by this defendant. It wasn't fired at this supposed intruder. It wasn't pointed at anybody. She wasn't charged. Nothing like that. It's just that she came out armed, ready to apparently confront whoever did this. I think later turned out it was a practical joke by some party goer that was there and tried to scare them. So I think it's not going to paint her in any kind of really bad light, other than she had the familiarity to retrieve the firearm and arm herself. So that'd be the only thing I can say would even approach any of this material on the defense motion, defense limiting number 4. Thank you.
All right. Stu?
I'm gonna ask the court.
Did you guys hear him, what he was saying, and what did you guys understand what he's saying? Okay, Mr. Steele's asking them to suppress the part where they're talking about gun violence. Because what happened is there was one day she was having a party or something like that, and someone shook the I think something in the backyard. They shook it, so she went straight inside the house and got her gun because she heard an intruder, I guess, at the time. So because she brought out her gun, supposedly it shows that she has the ability and the ability, not just the ability, but her stance on how quick she was able to go get the gun and be able to react to that situation. And it makes it her to show that she had the availability of that weapon, right? Supposedly, this is the weapon that was used during at the time of the husband's unaliving, and the gun supposedly belongs to her, which was a gift from her father. So that's what they're trying to bring up, that her having the availability of the gun, the ability to go get it quickly, and that type of thing, and showing that it was hers. So the possibility of her using it on her husband is great. That's what they're trying to say, and Mr. Steele wants that part suppressed. And you're gonna hear what the judge say on that part, okay?
To consider ruling that before the state goes into anything having to do with illegal drug use, Dr. Norman or otherwise, that need to approach this honorable court and take it up outside the presence of the jury
No objection.
to determine whether that would be appropriate. Everything else, I believe, the state is saying they will not introduce any type of character evidence except for this gun. It's my understanding that it's a different time. There's no nexus to this count or counts of the indictment. It's a different gun. They're different people. It's a different home. And it's justified because somebody believes it's an intruder. So I don't understand why we are putting in that person. I mean, I do that. Go into my house, get a gun, and come outside when I think there's an intruder, and now all of a sudden that's coming into my murder case. So I ask the court to exclude that, unless and until, obviously, there's more during the trial rolls out, and the state believes that it becomes relevant at that time. But to open up and say that, by the way, in another occasion, she runs out of the house with a gun. A lot of people do that, and that should not come into our trial. It's unnecessary. Under 403, I think there's no probative value under 401 or 402. And the way the state is using it, it does sound like character evidence, because otherwise, why are we introducing this fact? No one is to say that Ms. Boles has never claimed that she's did not know that gun was in the house. In fact, it was given to her by her father. It was given to her and the deceased. So that's all coming into evidence. It's a different gun, different time, different situations. I ask the court to exclude everything unless and until the court hears evidence that becomes relevant.
Anything else?
Yeah, Judge, thank you. If it pleases the court, I think that's a good point that Mr. Steele raised. We do anticipate the evidence to show that this gun that was used in the death of the decedent, either way, suicide or homicide, this weapon was the defendant's gun. This was given to her by her father. And again, showing the jury another instance where she came out armed ready to use a handgun. It just goes to show, again, her familiarity with using handguns. It's not somebody who's never held a gun, doesn't know guns. In fact, it's consistent with what Mr. Steel is apparently conceding, that this weapon was given to the defendant by her father, her weapon. The incident with the practical joke, we do believe it was a different weapon. I think it could have been the same weapon, but I think one of the party goers described as being black. The weapon killed the decedent was silver plated. But I think it's relevant. Again, this is going to a lot about the weight of the evidence, not the admissibility. Obviously, in Paulding County, there's going to be a lot of people, if not everybody, on the jury that owns guns. And this can be explained away concerning the weight of the evidence. Hey, so what? There was an intruder, there was a threat, she came out with a gun. That's what anybody would do. Sure, that's fine. That goes to the weight of the evidence. But the admissibility, that's not what it goes to, because the jury can attach whatever weight they want to the fact that she had familiarity with firearms enough to be the one person off the deck to go in, arm herself, and come out against this supposed threat. That's relevant, and I think it's not overly prejudicial. We're not painting her as some villain who had this gun. We're just painting her as somebody who had the familiarity to go arm herself and come out with a handgun. It's not a rifle, it's not a shotgun. It's the same type of weapon that was used to end the life of Daniel Akers, no matter which version you believe. That's the pistol that was used to end his life, the same type of weapon. So I think it's very relevant, I think it's very probative, very probative. And I'd ask that Your Honor just allow it to be viewed by the jury for whatever weight they attach it, which could be 1% or it could be 99%. That's up to them. Thank you.
Anything else on this motion? Nothing else?
Unless you need anything further, no.
Okay. I don't, I can see some relevance. I don't think it's bad character for someone to have a gun if they're for the front. There's anything wrong with that. So again, I'm inclined to let that in. I'll address it in order.
What's that? Yeah, we have a kind of another quick motion, Judge. It's the
Did you your court rule?
Sorry?
Your court rule?
Did I rule?
I didn't hear.
I said I'm inclined to let that in, but I'll address it in the order.
Judge, we can take another one that's pretty quick. Defense motion in limine number 3. So this is an interesting motion. The defense is moving the state or asking the court to limit the state, to order the state, not to be able to admit into evidence that Dan Akers, quote, was the type of person he was not the type of person that would end his own life. Hey, he's just not that type of person. He's not the type of person who commits suicide. I mean, I agree with that motion. So you won't see the state in this trial ask any witness, any state's witness or defense witness, hey, was Dan the type of person who would end his own life? We're not going to ask that. Nobody could get inside the mind of Daniel Akers on December 21st, 2020, December 22nd, 2019. Nobody can get inside his mind. We don't know that. So nobody else could know that. So we're not going to ask people, was he the type of person that would have ended his own life? No, that's not an appropriate question. We're staying away from that. But we do plan to ask, were there times you saw him deeply depressed? What type of person was he? What was his personality? We expect the answers to be, he was upbeat, he was a jokester, prankster, always looking at that glass half full. We expect answers like that because we expect that's the type of person he was. Did he ever approach the issue of suicide with you in your conversations? And these are people that worked with him every day. We have coworkers, we have family members, very close family members. Did he approach to you that he had been so depressed that he just couldn't get over it, that he saw no outcome or no way out of this depression? And we expect the answers to those questions to be no. So while no one can know what was in his mind on that particular night, the last night of his life, I do believe it's relevant to ask witnesses who knew him very well whether or not he expressed deep feelings of sadness, being overcome with grief, inability to move forward, whether or not he had ever brought up the issue of suicide with his coworkers or family members. And I think that's different than asking somebody, was he the type of person that would kill himself? And again, let's just say I asked one of his coworkers, hey, you guys talked all the time, is that right? Yeah, we talked all the time. Every day at lunch we would talk, and we were on the job together for years. Did he ever talk to you about suicide or being overcome with grief or deep depression? No. Cross-examination would be, well, you don't know what he was feeling, do you? You don't know what he was going through. Sometimes men don't want to share that. Isn't that true? And things like that. So again, weight of the evidence. This is able to be addressed in cross-examination. But it shouldn't be held to be, this area of questioning shouldn't be held to be completely inadmissible because it has some value to the jury. At least I believe it might. And I think it's certainly relevant. It's in the defense theories of the case is that this was a suicide. So our theory is it's a homicide. So I think it's certainly relevant. It goes to the core issue of the case. It's not who did it. It's what happened. What was done, not who did it. I mean, we know the man died. It's just, was it a suicide or a homicide? And I think what his approaching these feelings or expressions of these feelings of sadness, grief, depression, suicide as a topic are relevant to that issue. And I think the court, I respectfully ask the court to allow it in. But I do agree with the specific nature of the motion. We will not ask if he was that type of person, whatever that would mean. Thank you.
All right, defense?
We rely on the rules of evidence based upon the prosecutor's statement to the child report. I don't know how many of those statements come in. So I don't believe it comes in at all.
Okay, I'll address it in my motion, and order on the motions. Next.
There's another quick motion, and just to be clear,
Everything would be hearsay from what the prosecutor just said. I assume the court knew what I was saying when I said a lot of the evidence, but the court seems like maybe he's shaking his head. But that's what, you're getting into conversations,
I was shaking my head.
and the person's not here. So that's it's a hearsay objection as well.
I don't think it is hearsay, Judge, and here's why. Hey, did Dan ever tell you he was gonna commit suicide? That's hearsay. Did Dan ever bring up the topic of suicide? Did you ever hear Dan did the conversations you had with Dan include deep depression, feelings of grief, sadness, overwhelming despair? Those are topics. Those aren't, what did he say about that? Those are topics of conversation, not specific statements. The only thing banned by hearsay are statements by the out-of-court declarant. Not topics of conversation. Hey, you guys had lunch every day at Piedmont Hospital where he was a sheet metal worker. Did you ever talk about suicide with Dan? No. Did you ever have cause to believe he would take his own life? No. Not was he the type of person that would commit suicide based on knowing him? Not that. But did you ever talk with him about suicide, his happiness, his despair, his level of grief? Did you ever talk about those things? And then I would not go further. Well, what did he say? Because it's hearsay. But whether or not these topics, these general topics were discussed is not hearsay. That's relevant. Thank you.
All right, thank you.
There's another pretty quick motion. Let's see. All right, so Judge, defense motion limiting number one. There's some facts in this case that we anticipate being able to show beyond reasonable doubt at trial that after the death of the decedent Daniel Akers, well, let's back up. Before his death, we anticipate evidence showing that two people named Christopher Berg and Amanda Berg sold a car to Daniel Akers on some kind of a payment plan. He was going to pay them every month or whatever it was, and he paid for this car, and they sold him this car. So after the death of Daniel Akers, this defendant, shortly after the death and funeral of Daniel Akers, this defendant returned the vehicle to Amanda Berg and Chris Berg because now you have the decedent having died. He hasn't made the full payments for the car, and we believe the evidence would show that this defendant arranged to deliver the car personally back to the home of Amanda Berg and Chris Berg. Now these people were not just used car salesmen, these people were family members of the decedent. This was the decedent's sister, a person he considered his sister to be his sister. There's some complicated family involvement involved in the case, but basically he considered Amanda Berg to be his sister and her husband. So it was a family sale of this car to Daniel while he was in life. After he died, this defendant arranged to go over to the house of Amanda Berg. Now remember, this is people, Amanda Berg had spent a lot of time with this defendant personally. They were family after all. They spent a lot of time together. Chris Berg had spent a lot of time with the decedent. He worked with him. So these are very close-knit people, very close-knit family members who spent a lot of time with each other before the death of Daniel Akers. And after the death of Daniel Akers, we believe the evidence would show that this defendant arranged to personally have the car delivered back to the home of Amanda Berg and Chris Berg, and then drove it into the driveway or in front of the home of those two people, Amanda and Chris, and then just left it. And left. Car ride, got a ride, took an Uber, took a Lyft, whatever, and then texted Amanda Berg, hey, the car's in your driveway, see ya. And I do have Amanda here to testify. I'm just proffering, but she's here outside, subject to the rule of sequestration. So she could come testify to exactly what happened if you need to hear it. I'm just proffering to give you an idea of the nature of the motion. And we are planning, if permitted by this court, to call Amanda to the stand for a number of things, a number of points. But one of them is the very, what I would consider on behalf of the state, very strange interaction of you're very close with these people. Daniel has just died, according to you, committed suicide. If you're the defendant, according to the defendant, his suicide. He's just lost his life. It's a tragedy, as Mr. Steel said earlier. And you return this car to your family members, but you don't say anything. You don't come in. You don't have any interaction with your family members. You just return the car and text them, your car is back in your driveway, see you later. So I think, again, that goes to the weight of the evidence. If the jury draws absolutely no importance from that, or no weight to it, if they attach no weight to it, fine. But it is relevant. It's relevant to show consciousness of guilt. It's relevant to show the shame of guilt and this defendant's consciousness of guilt. Because the state's argument is that she murdered this man, and now she's in possession of his car. And by the way, his car came back sanitized clean. Every single thing had been removed from it, and it looked like it had been like it was from a factory. It had been cleaned. It was, you could eat off it. And it's an old car. This is like a 20-year-old car, 15-year-old car, and it comes back left in the driveway of Amanda Berg's house, just absolutely polished. Hey, your car's back in the driveway. I mean, that has relevance because it shows consciousness of guilt. This defendant doesn't want to confront her family members when she returned that car. She doesn't want to see face-to-face Amanda Berg and Chris Berg. Why? Because she murdered their brother. And that's the relevance of it. And that's consistent with the state's theory of the case. And it's not overly prejudicial. Again, it can be explained away and cross if that's what the defense chooses to do. Under no duty to do anything. But they could, if they choose to hey, maybe she's uncomfortable, maybe she's still in mourning and grief, whatever. But it deserves to come in before the collective minds of the jury for them to consider it. I think the court can agree that it's extremely abnormal behavior if your brother just committed suicide and his spouse just drops the car off in your driveway and leaves and says nothing. It's very unusual. At least that's what I hope to show the jury if I'm allowed to do so. So I think that is relevant. And I don't think it's overly prejudicial. I think it's almost a situation and it's a weird situation to be in arguing this motion because it's almost like the relevance of it is illustrated by the fact that the defense wants to exclude it. So it almost shows its relevance by the fact that they don't want it in. If it wasn't relevant and it had no bearing on anything, they wouldn't care if it was coming in. They know it's relevant and they know it's extremely prejudicial. So they want to exclude it. That's why the motion is filed. But I think its probative value is huge. I think the jury's going to think, man, you know, that tells a lot. That says a lot. That speaks volumes. She didn't even have, these are her family that she was super close to. Hey, your car's back in the driveway. I'm out. You know, that's relevant and it's not overly prejudicial. It's very probative of her consciousness of guilt and what she's experiencing at the very time after the death of this man. Thank you.
Mr. Steel. Anything on that one?
I'm just strained to see any relevance under 401, 402, 403. The prosecution says consciousness of guilt. I've searched that. I can't find anything close to using consciousness of guilt to returning a car and saying it's in the driveway and it's clean. I can't find a case. Consciousness of guilt generally is flat. That's a typical consciousness of guilt. You know there's a warrant and you flee. You know there's a crime and you flee. We now are just going, I guess, according to the prosecution, just throw everything in, no type of barrier, and just let the jury decide what this means. I find this to be highly prejudicial. I didn't file a motion because it's relevant. I filed a motion because it's not
say, I don't see a lot of relevance to her returning the car in that way.
Yeah, Judge, it's not, again, it's not really the fact she returned a call. Obviously, we wouldn't get into that. It's the circumstances surrounding it and the way that it was done. Very abnormal. I think, again, I'm asking the court not to just open up a floodgate for anything, but I think under 4.3, this is irrelevant because of the circumstances of it and the circumstances, the totality of the circumstances of it. And I've asked the court just to allow the jury to pick whatever relevance they want on.
All right, I'm taking all this under advisement. I'm gonna think on it some more, but I do think under 403, the relevance would be very small. And as far as the unfair prejudice factor, she a bad person or did something wrong for kind of being flippant in the way she returned the car. So I could see a little bit on the other side of 403.
I would just ask the court to take a look at the line of cases that indicate that the rule of relevance favors a disability. It favors the jury being able to consider it for whatever, even if it's scantly relevant. If it's relevant at all under 401, then the law favors a disability. So, thank you.
Thank you. All right, moving right along, what is next?
That may be it, except for the most time-consuming one. I think we're up to the last one. Let me make sure. Oh, I had a motion kind of quick. I'm sorry, the state propounded a motion, Your Honor. It's a motion to amend an unmanned audio recording. Let's see. Here it is. State's motion to limit number 1, motion to admit cellular telephone audio recordings. So in this case, Your Honor, if it please the court, there was a forensic download and examination done of the decedent's cellular telephone in this case. And one thing, and I have witnesses outside who could tell where this recording was found and that it wasn't manipulated and it was just found on the decedent's phone. But just for stating in my place and making it proper, I think we agree that on the decedent's phone, there was a audio recording that was found on his phone, whether it was the voice memo app or voice memo on an Apple phone where you push the voice memo and it records what's happening. There was this recording that was found on the decedent's phone. He seems to be in the company of his young son. It sounds like from the context of the recording, they're playing video games. And while we cannot know exactly why the decedent chose to record this phone call, it was found on his phone. The young son, he's 6 years old at the time, so it's doubtful that he manipulated the phone to make it record. I think we have to assume realistically that the decedent chose to record this interaction. The interaction captures a very incredibly violent, I would say it wasn't violent physically, but it was emotionally violent argument between this defendant and the decedent. They're obviously in some kind of an argument, a fight, if you will, not physical, but verbal. And really, I wouldn't even say it's a fight, rather as much as it's this defendant verbally abusing this decedent. And the date of the recording was December 19th, I believe, 2019. So December 14th, 2019. In the teens of December, right before the death of this decedent on December 22nd, 2019. So it's very close in time to his death. That raises the relevance of the recording. There's going to be a lot of testimony in this case about marital difficulties between these two parties, marital disagreements between the parties, violent arguments between the parties. In fact, there'll be text messages admitted into the case. I'm almost certain that'll show on the date of immediately the day before this decedent's death how these parties were going back and forth, verbally texting each other, very aggressive texts. I mean, it was angry. They were angry at each other. At least this defendant was angry at the decedent. So right before this happened, within a week or so, 10 days before his death, he pushes record on his phone and captures this argument from this defendant, screaming at him, berating him, belittling him, and that's captured on audio. And I believe it's relevant to show.
All right, let me get the other one. Sorry about that, y'all. I'm trying to do multiple things at the same time. Hold on a second. That was 184. Now here's no, which one was this? This is 180. Hold on, this is 183. Okay, now we're gonna go to 184. Just 1 second. 184. All right, here we go.
Recording device. And we do have witnesses to lay the foundation for it, that's authentic, there's been no alterations, no deletions, no
Yeah, if it takes me a little while to get to it, just bear with me because I'm multitasking.
copying, no manipulation of the recording. It goes about a couple minutes, not long, but it gives I think it gives the jury an incredible insight into the dynamic between this defendant and the decedent in a week before his death. I think it's incredibly relevant, especially some of the things she says on there, which the jury can conceive to be an absolute threat to his safety. So I ask the court to admit it for whatever weight the jury gives it. Thank you.
All right, any response, Mr. Steele?
I'd like it to be, the recording, to be marked as an exhibit for your honorable court to listen to. I think that should be the first step. And then, of course, we're not waiving any authenticity objections that would have to be complied with at trial. The honorable court make a ruling. But when you listen to it, we don't believe that it should come in at all. But I believe that the evidence needs to be heard by the court before you can make that type of decision. And then we can either revisit it if you want to hear more argument, or you could preliminarily admit it if the state can lay a foundation.
All right. The lawyers have heard it, I haven't heard it.
Yes, sir, and if the defense wants to enter it, they can, I guess. They have it.
I think
Well,
the
It
state.
would help me to make a ruling on my head.
I'll mark it as state's exhibit 4, Your Honor, and if the court could just reserve ruling on it until the court's heard it, or I can wait another court, it might take me a minute to set it up. But I'll be happy to admit it into evidence of state's 4, and the court can listen to it off the bench.
Why don't we do that?
Yes, sir. May I just have till the end of the afternoon to get that
Yes,
ready?
sir.
Thank you. I think that completes all of the motions the state had and all the motions I'm responsible for. Oh, we did file a motion, Judge. As you know, Your Honor, respectfully, I'm new to your courtroom, so I don't know how you exactly do things, so I filed a motion pursuant to 15-12-131. It's hard for me to keep track of all the potential jurors if they're questioned among the whole courtroom, so I've asked you to see 12 in the box at a time, so I can examine 12 at a time, I think.
Well, here's what I do typically. I'll go downstairs to the jury assembly room, and I'll just ask some statutory questions, just so if somebody doesn't live in the county, we can investigate that or something like that, or they're clearly, I don't think I've ever had this happen, but somebody gets someone who's not old enough or something like that. And just kind of orient them, and then come back upstairs, and what we do is we go ahead and bring up everybody, so 3 panels. And with y'all's permission, I will just bring up 36. Maybe we'll put a couple extra in the third box, or maybe we'll do panels of 14 or something like that, with your permission. Make introductions, go through all the statutory questions, and then I will ask just some real basic questions. This will be number 1, and we'll run across 6 or 7, and then 8 will be behind number 1, and so that's 1 panel, that's a panel, that's a panel. Typically we do this in courtroom 1, because it's bigger and it's just easier for the clerk to shuffle them from the jury assembly room into courtroom 1 and back. And I'll ask, state your name, are you married? What do you do? What's your spouse do? Just
Area of the
very,
county, things like
very,
that.
very basic,
Yes, sir.
and y'all can take notes.
Okay.
Then I will send out 2 and 3 and let y'all focus on 1 panel at a time.
I think it's probably a good time to also, since we're talking about jury, we've arrived at a consent agreement on a questionnaire, and maybe we could approach that issue with the court now, since we're talking about kind of voir dire. We didn't have time to arrive at a consent on sending the questionnaire out in advance, like when they get their jury summons, but we would ask the court, I think I'm authorized to join with defense counsel, we would ask the court possibly to distribute the questionnaire to the potential denier, allow them in 45 minutes or so to answer the questions on the questionnaire, and that would hopefully ultimately shorten the time it would take for voir dire greatly, and it would allow us to have a written record each side of what they said and their answers were, and we would know a lot of the answers to the questions before we even got started. We submitted, or Mr. Steele's office submitted a consent questionnaire to Your Honor's chambers.
They submitted what?
They submitted a consent questionnaire to Your Honor's chambers that the state signed off on it, the defense signs off on it, and we'd ask the court to consider allowing that to be distributed right after your statutory questions to the jury downstairs. And
I
having
have, I'm sorry.
giving them a little time to answer that before they.
I have an amended, unopposed motion for a jury questionnaire filed May 15th with a jury questionnaire attached. Is that?
I believe that's it, Judge. I share in the defense belief that it would shorten voir dire greatly if Your Honor would entertain it.
Well, I was a little concerned it might lengthen the process, but maybe I'm wrong. There's some questions on here that I typically don't allow, but you both want it, just like this. That's what I'm hearing.
Yes, sir. I believe we arrived at a consent for that version.
Well, I know this is, y'all don't wanna lock yourselves in, but what do y'all anticipate for voir dire? Do you think we'll have a jury Monday, or what do you think?
I'm doubtful on that. I would say probably take half a day Tuesday, maybe.
Defense doesn't care to speculate.
I don't disagree with that, Judge. Of course, we'll try to be as diligent. That's why we did this questionnaire, Judge. We're actually thinking at the end of the day, it's gonna help us get it a little quicker, whether that's 1 or 2 or 3 hours quicker, I don't know. But it's gonna help us both, and we'd like the court to.
All right, so somebody is going to, I suppose, give me, or give the clerk several dozen copies of this.
Sure, I'll prepare, if Your Honor orders this questionnaire the morning of, I'll deliver to
Y'all
your.
both agree, then I'll do it.
All right, I'll give your chambers 48, is that enough to start? Done the morning of?
Sure.
All right, 48 copies or 50 copies, and then, we'll just take direction from the court if they've had a chance to fill it out. If Your Honor could, just include in your orders, if you will, have 12 or 14, so I can just have my.
Well, I
chambers.
can't have more than 12 unless y'all agree.
I don't have a problem with 14, but if that's what you're.
Is that okay?
12 only? Mr. Cole was 12 only, he counts in numbers of 12, so I guess we'd ask for 12 per pound. 12, 12, 12.
That'll probably guarantee a fourth pound.
I mean, we can only get a 14.
The defense lawyers were shaking their, or nodding their head that they were okay with 14, but.
14 is fine, we do 14.
14, okay?
Yes, sir.
All
That's
right,
fine.
I appreciate that.
All right, so that's, I think, it for, we did file several notices of business records. Go ahead, sir.
Can I ask a question?
Yes, sir.
So, thank you for agreeing to give the jury questionnaire. Do we not then submit jury questions to you next week?
Well, this is the first time I'm using the questionnaire. What I typically do is I have the lawyers submit proposed voir dire questions, I go through them, and I eliminate some of the questions and hand them back. And the other side never sees what I eliminated or what you gave me. I would assume that since you're using this questionnaire, these are the questions you're gonna ask, and then of course you'd be allowed reasonable follow-up to these questions. And you wouldn't be coming up with something out of
That's right, I just wanna make sure we don't violate your order.
All right, so based on that, you do not have to give me proposed, or dire questions, and I believe the state has already given me some, but it's just,
Well, that's not exactly true, and it causes me to consider my consent to this jury questionnaire. Then if I'm gonna be limited to only the questions on that questionnaire, then I withdraw my consent to the questionnaire. Because I have questions that are on, the questions that I submitted to your chambers, they're not on the questionnaire. And these are just common
let's do
how.
this, let's do this. If you want to ask additional questions, just get them to me by the day.
Okay. All right, thank you. And then we did file a notice of business records for Ms. Boles Wellstar Healthcare Records. She was admitted to the hospital on December 22nd, 2019, immediately after the police response to her home. This defense is objected to the entry of those records or the admissibility of those records. Again, I don't think we'll be using those records at all, but there's a possibility, again, that some of these records could become admissible if the door is open. Again, I'm concerned about this testimony or potential testimony from Dr. Matthew Norman, the forensic psychiatrist. He, I believe, is going to attempt to use these records to show that this defendant was administered certain drugs at the ER on the date of the death of the decedent. And I think if that happens, then we have a right to use not the totality of those medical records, and we're not bringing up things that in our medical history that are not relevant to that issue, but I think we have a right at that point to cross-examine Dr. Norman with anything in the medical record history that is relevant to whatever he's testifying about, if that makes sense. I anticipate he's gonna be testifying that this defendant was administered some drug in the ER that could have affected her short-term recall or memory and things like that. It could have affected the veracity of her initial interviews with police. Well, if there's something that's counter to that in the medical record, or if she was administered XYZ, something else in the medical record history, or if there was a condition such as chronic illegal drug use in the medical history, that becomes relevant to his testimony. So then I would rely on those medical records. So I don't know that we can really, I don't know the court can really address that until such time as the door has been open. But I'll certainly state in my place that before I go into something like that, I would approach the court and say, hey, we think the door's been open on these medical records. And they are certified business records. They do have the custodian's stamp and seal on it, and that's returned over to the defense. Thank you.
Thank you. I don't think that's really a motion, but you can respond if you like.
So long as we could take this up, because there's a lot of hearsay and inadmissible information in there, but as long as we have an opportunity to discuss these medical records in toto before the court allows it to go into, that would be fine.
Okay? That will work. If that's all for the state,
Yes, Your Honor, Mr. Cole's going to address one of the defense motions at this point. Thank you.
Can I just say one thing before we move on to the next motion?
yes, sir.
Is that okay? There's a lot of recordings of Ms. Boles. I don't know if the court, it's ours. And what I propose to the court is maybe I could get together with the state and we could see if we can agree to redact certain portions. Because certain portions have nothing to do with the trial of the case and would be, in my opinion, prejudicial. So after that, can we come to the court with any disagreements?
Of course. If y'all can bring me something that I can address without the jurors sitting there waiting, that's very helpful.
I think that would be good. Maybe we can agree on transcripts or times, and then anything we don't agree upon, we can just land that in the lap.
You're talking about before the trial starts, coming back?
I would like, I don't even know if we have to come back, but sure. Yeah, we would not do it, hopefully with the jury time. We would try to get it to the court before that. That's my belief. I don't know if it's prosecutors. I don't want to speak for anybody.
So you would like to come back before the trial starts if there's any disagreements about what needs to be redacted?
We could, or that's fine. I was saying we may not even have to come back as long as we can articulate to the court and get you the actual recording. But whatever the state wants to do in the court, I just don't want to be objecting. The jurors have to go out and we say, well, this portion now should
shoplifting warrant, the drug use, those are on video, we're going to redact that, but I can't respond to something that I don't even know what's being put on the table, but we're open to listening to the defense. Hey, we don't think this is relevant, or it's overly prejudicial, would you consider redacting it? I'm always open to that, but I thought the crux of it has been addressed, I thought, but I'm open to hearing from the defense.
I would appreciate y'all working on that before the trial starts, and then if y'all could be here at 8:30 that morning, the jury will just start working on the questionnaire at about 8:30, and we'll have probably close to an hour. You can report to courtroom on the first floor, because that's where we will conduct more dire, and then once we pick a jury, we'll move up here, it's more comfortable. So that'll give us some time if anything else comes up. Mr. Steele, was there a motion that wasn't presented, or?
May I have one moment, Your Honor?
Sure.
There is one more, Mr. Lau just stated, Your Honor. But I think that's one that the state said, this is the, hospital search.
Yes, sir.
Search of our home at the hospital. There's one more left.
Okay.
Can I ask a question while the witnesses are going to be called on that? Do we, just for scheduling of witnesses, do we have an estimate of how long the state's case is going to be?
I think this case, Your Honor, respectfully, I know Your Honor doesn't want to hear it, but I think this case is going to next week, June 22nd.
Oh, that's what I was told, so that's what I was expecting you to say.
All right, thank you. We don't, this court, I know defense counsel is inquiring about Juneteenth. I don't think the circuit has Juneteenth as a day off.
Okay. That was my question too. So we're working, Friday the 19th.
Well, the courthouse is open.
Okay.
It is. I have several witnesses outside, Your Honor, that were potentially witnesses in some of the earlier motions. When they come back in and out, they won't be partaking in this motion.
Was that everything, Mr. Steele? No, all right.
I believe that's everything, yes.
Okay, all right, that'd be
Thank
fine.
you. Okay.
All right, any other questions, logistics, anything at all? There's a coffee maker in my office, y'all are free to visit it as much as you like. Take breaks whenever a hand goes up, and not about every hour and a half. Start at 8:30 the first day, work till 5. Then after that, 9 o'clock to start. And if I go past 5, if we're in the middle of a witness, typically I'll get the jury's permission, make sure nobody has to get home to a kid or something like that. We shouldn't go very late. Anything else?
Just the last motion, Judge.
What is that?
It's a motion to suppress search.
Okay,
Mr. Colt's going to handle that.
I'm ready when you are.
State call Brent Miller.
No need for break?
No, Your Honor, it's basically a argument by the defendant that she was unable to consent to the search of her home.
Sir, do you swear or affirm the testimony that you give the truth, nothing but the truth, so help you God?
Yes, sir.
Could you state your name, please, sir?
Yes. Brent Miller
And how are you employed?
at the Polar County Sheriff's Office.
How long have you been so employed?
29, going on 29 years, one way.
Okay, and you are a captain now, is that correct?
Yes, sir.
And in March of December of 2019, or what was your rank at that point?
I was sergeant, sir.
Okay, and what were your duties in December of 2019?
I was assistant to the shift commander.
Did you get called to a location on December 22nd?
Yes.
Of 2019?
Yes, sir.
And what were the nature and circumstances of you responding to that particular location?
We responded to a person shot.
Okay, and when you got to that location, how many people were there from law enforcement when you arrived?
Well, when I arrived, it was just me, sir.
Okay, and what, if anything, did you do upon arrival at that location?
When I got there, the defendant was standing there at the front door, was hysterical, screaming about someone being shot.
Okay, when you say the defendant, of whom do you speak?
Ms. Boles right here.
Okay, let the record reflect, he's pointed out the defendant and identified her as Ms. Boles. Now, you say Ms. Boles where was she located when you first got on the scene?
There at the front door.
Okay, so then what, if anything, did you do?
I came up to the front door and she showed me, or told me that the person that had been shot was downstairs. Cause it was a split level house. You would go up the stairs or down the stairs. So I went down the stairs, it was a half basement to the left, and the deceased was there on the floor.
Okay, now, prior to your arrival at that location, did you have any idea where the person shot was located in the home?
I don't believe so.
And did you have any trouble at all understanding this defendant when she's trying to explain where the person shot is?
No, no, sir.
Okay, even though she was hysterical, you could understand her, is that correct?
That's correct.
Okay, did you continue to converse with the defendant at that time?
I went down, to the basement and checked on him. He was obviously deceased. At that point, I came back up to the landing and she was right there at the landing and the stairs. And then I ended up being upstairs the rest of the time with her, helping her take care of the children. And Captain Pace was the second one on the scene, and he went downstairs and he secured that area down there.
Now, when you were on the scene, did you have any trouble communicating with this defendant at all?
I mean, she was crying and hysterical, but I mean, no problem communicating with her. I mean, as far as what she needed me to do to help with the kids or vice versa.
So was she kind of telling you what she wanted you to help her with?
I wouldn't say that she was telling me what to do, but there was communication between us.
And at that point, she's not in custody or anything like that?
No, sir. No, sir. At that point, from what I'd understood, from what I'd been told from her, was that her husband shot himself. So.
And so you never arrested her that morning?
No, sir.
And this is a little after midnight, is that correct?
Yes, sir.
And, were you able to communicate with her effectively? Did she have any trouble comprehending what you were saying?
No, sir. Not that I recall.
Okay, did you have any trouble understanding what she was telling you?
No, sir.
And anything that she told you was freely and voluntarily given to you, is that correct?
Yes, sir.
And there was not a Miranda warning given or anything like that, is that correct?
No, sir.
And she wasn't threatened with the remotest fear of injury and she wasn't promised anything, is that correct?
That's correct.
How long were you on the scene there with her?
I was on for, it was probably a couple hours, I mean, total that I was there.
Okay, now at some point she left that home, didn't she?
She did.
And what happened to cause her to leave the home?
The paramedics had come out to check her and had checked, I guess her blood pressure was high, or I don't really recall exactly what happened, but they checked her and I don't remember if she left in the ambulance or if she left with somebody, but she
Okay, let the record reflect that, Captain Miller just winced and he is under some physical duress at this point and he's here. And if you want to explain to the court what problems you're having, and we will take a break and.
no, I'm fine, I can get through
Okay.
it, but
You know, what is exactly going on with you physically? talking to, the defendant, she's there with the children, and are you upstairs with her with the children?
Yes, sir.
Okay, and so how many children are up there?
I recall two, I believe it was two that was up there. That, there may have been one that was sleeping, but I don't recall exactly
All right.
the number.
Now, when she left, what happened with the children? Who was watching them?
There was a family member that had showed up.
Okay, so she didn't leave until this family member arrived.
Correct.
Okay, did she tell you the family member was on the way to help her with the children, or do you recall?
I think she had called the family member to get them to come, but I don't recall. I didn't call the family member.
Okay, any time you were dealing with this defendant on that morning, did you have any trouble communicating with her?
No, sir.
Did she give you any indication that she had any trouble communicating with you?
No, sir.
That's all the questions I have.
Cross.
Captain, we hope you're okay.
Yeah, I'm good, thank you.
When you went into the lower level of the home,
Yes, sir.
what did you do exactly?
I went down and I don't recall if I even checked for a pulse or anything. I mean, it was an obvious deceased person. And then at that point, I walked back upstairs.
You don't remember whether you did any type of, check to see whether the person's still alive? You don't remember?
I don't recall if I did or didn't.
Now, Lacy Boles was, would you describe as a, I don't know if this is fair, 10, she was hysterical, I think.
I think hysterical would be a good word. She was crying and, I mean, she was hysterical, would be the word I would use.
Okay. All right. And she was brought to the hospital for health conditions, is that true?
I don't recall the exact reason that she was taken. I believe the paramedics had checked her and her blood pressure was high or something like that.
Regardless of the,
For some reason, she went to the hospital.
for health reasons.
I'm assuming.
That's why people go to the
That's why
hospital.
people go to the hospital.
Unless they work there or something.
Yeah, yes, sir.
Okay. I hope you get that.
Thanks.
Anything else for this witness?
Well, just to follow up on, what Mr. Steele was asking, at any point in your conversation with this defendant, did she indicate to you that she couldn't understand what you were saying?
No, sir.
At any point in your conversation with this defendant, did she have any trouble communicating to you, where you had trouble understanding what she was trying to convey to you?
No, sir.
That's all the question I have.
Anything else for this witness?
No.
All right, thank you, sir. Step down.
Appreciate it.
Any other, have another
State
witness?
College Detective Ogden.
Thank you for watching the infamous Sylvia channel, where laughter and fun make up our panel. Together we build this digital spree. We appreciate you and our growing family. With mods by our side and chat flowing free in this online space. It's just you and me. We laugh until tears roll down like the rain. In this virtual world, you ease all my pains. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We cherish the moments, the highs and lows, from the latest gossip to stories untold. You're more than a viewer, you're part of the crew in this space of ours. It's all because of you. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night. This digital world where emotion is shared, every post and reaction showing we care. The love is real in this virtual domain. With every sign, enjoys what we'll gain. We're a family, not just a show. Every click and comment makes us grow. Mods and chat, keeping the vibe so right. Together we shine like stars in the night.